Hello and a warm welcome to Federal Special Program Capital Beat. Supreme Court today called the Bihar Special Intensive Revision, that is SIR Rao, largely a trust deficit issue. As the Election Commission of India claimed, roughly 6.5 crore people of the total 7.9 crore voting population didn't have to file any documents for they or their parents featured in the 2003 electoral roll. Now, the top court is, as everyone knows, is hearing a batch of pleas against the Election Commission's electoral roll revision exercise in Bihar. A bench of Justices Surya Kant and Joy Malia Bagchi during the hearing remarked that it largely appears to be a case of trust deficit, nothing else, as it questioned the petitioners challenging the EC's June 24 decision of conducting the SIR on the ground that it would disenfranchise 1 crore voters. And what did Kapil Sibal say? He said that if out of 7.9 crore voters, 7.24 crore voters responded to the SIR, it demolishes the theory of 1 crore voters missing or disenfranchised. This is what the bench, I'm sorry, the bench told Kapil Sibal, who appeared for the petitioner RJD leader Manoj Jha. The top court also agreed with the EC decision to not accept Aadhaar and voter cards as conclusive proof of citizenship in the ongoing exercise and said that it has to be supported by other documents. Kapil Sibal then contended that despite residents holding Aadhaar, Ration, and Epic cards, officials refused to accept those documents. And what did the bench say to that? Bench said that is it your argument that people who have no documents but are in Bihar and therefore he should be considered as a voter of the state? That can be allowed. He has to show or submit some documents. This is what the bench said. When Sibal said that people were struggling to find birth certificates and other documents of their parents, Justice Kant to that replied that it is a very sweeping statement that in Bihar nobody has the documents. If this can happen in Bihar, then what will happen in other parts of the country? Then senior advocate Abhishek Manu Singhvi and advocate Prashant Bhushan, who were representing different political parties, also questioned the timeline for the completion of the exercise and the data of 65 lakh voters who were declared as dead or migrated or registered in other constituencies. Then political activist Yogendra Yadav also, who addressed the court in person, questioned the data given by the poll panel and said instead of 7.9 crore voters, there was total adult population of 8.18 crore, and the design of SIR exercise was to delete the voters. The EC were not able to find any individual whose name was added, and the booth level officers visited house to house for deletion of names. This is what Yogendra Yadav said, and he called it a case of total disenfranchisement. Sibal then, during the hearing, said that while in one constituency, contrary to the poll panel's claims, 12 people declared dead were found alive. In another instance, alive persons were declared dead. Then Rakesh Dwivedi, who was the lawyer for the Election Commission, appearing for the poll panel, said that the exercise of such a nature was bound to have some defects here and there at the draft stage. And to claim dead persons were declared alive and alive is dead could always be corrected as it was only a draft roll. Then the bench in the beginning of the hearing told the ECI to be ready with facts and figures, for it would be questioned over the number of voters before the exercise commenced. There is a number of dead before and now aside from other relevant details. And now the next hearing, of course, will resume tomorrow. So how would one decode the day one hearing on SIR? What are the big takeaways from day one? And does EC, does the top court seem to be backing the Election Commission on SIR? Those are the big questions. Joining me this evening is renowned election data scientist Dr. Pyare Lal Garg. So thank you so much for joining. What would you really say towards the takeaways of the day one hearing on SIR in Supreme Court?
It will be when the people sitting in the highest office, that too in judiciary, when they start saying something, they pass maybe a request type of not an order. They just suggest, and the day the other party says, no, 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 we will not agree. And they say, okay, don't agree. Then why do they suggest? They should ask there and then. So whatever is happening, it is really sad for the whole of the country, for our democracy. One, When they say Aadhaar is not a proof, whatever we is not the proof, the registration of electors rules 1960 and the People's Representation Act 1950 are the acid test for us. We have to test the whole exercise on these two issues. Now, both the documents do not support the ECI. Then what is the Supreme Court for? If the Supreme Court is not to interpret the law, even is not to direct the implementation of the law. Section K, subsection 4 of the Representation of People's Act very clearly lays down that if at all a document can be sought from an elector who is either to be registered or whose name the EC wants to remove, the only document can be asked is the Aadhaar. And the amendment has been made and in 2022 only by this government itself. Now, if the Honorable Supreme Court is not ready to implement the act without its further amendment and all that, and the EC says no, we will not stick to the act, then what is the answer? The answer is that our democracy, our we are not being governed by the Constitution of India or by the laws framed thereunder by the Parliament. We are governed by the individuals, howsoever high they may be. It is only their whimsical approach, arbitrary approach, their own thought process,
No,
their
but
own
Dr.
consciousness,
Right.
but
No, Dr.
not the law, not the law.
Right.
With
No,
due
but
regard to everybody, I want to say
Dr.
this.
Garg,
Yeah.
the bench to say that SIR seems to be a case of trust deficit. What would you really say to that? Because very clearly, Justice Surya Kant and Justice Bakchi said that this largely, I mean, SIR largely appears to be a case of trust deficit. What would you really say to that? Does it go to show that the bench
This
is not sensitive to the right to vote? The bench, is it not sensitive towards the rights of the citizens and the way they are running from pillar to post? Is the bench not aware of that?
to my mind, this can be interpreted both ways. It depends upon them. When they say it is an exercise of trust deficit, the trust deficit is in the ECI, in their team, who are not listening to the people, who are doing every arbitrary action, illegal action, unconstitutional action, in a hurry, and forged action, fraud. They are committing a fraud. So it is a trust deficit. You can say this way. The other way you can say because they are doing everything against the law, the people don't have a trust in it. So they say the people don't have trust. You feel it is a trust deficit exercise. So the way they want to interpret it, this is only a statement. But from the rest of the thing, we cannot take this statement in isolation. We have to see the statement in the gamut of the whole thing which is happening. All the arguments are the responses, are the reactions, are the observations by the honorable court. Now the honorable bench has said Aadhaar is not a proof of identity, and they're quoting some Aadhaar Act and all that. Okay, fine, it is not a proof of identity, citizenship. But where is it written that where is it the provision that the Election Commission of India is to decide the citizenship? Who is to decide the citizenship is the Home Ministry under Article 5 to 11 of the Constitution of India. The EC has no right to decide the issue of citizenship. The EC can seek only those documents which have been prescribed by the Parliament of the country, by the legislature of the country. No, they are not ready to accept. And the Supreme Court is either not scrapping let the Supreme Court come forward and scrap the Representative People's Act 1950. Let them scrap the registration of electors rules 1960. Let them scrap the conduct of election rules 1961. Let them scrap the registration of deaths and births 1969. Let them scrap the letter issued by Mr. Ganesh Kumar himself on 1st of May 2025. So what are they doing? Are they doing as individuals the law experts of the country, or they are working in an institution as the highest judges in the highest court of the country, and they are to perform their duty as per law. I am a surgeon. One is I start, can I kill the patient? Do I get the right to kill the patient because I am a super specialist? I'm sitting in a big medical college. I'm sitting in a postgraduate institute. Do I get a right? I have to perform as per the literature, as per the rules, as per the procedure. I cannot. And these people daily ask us, why did you not do this X-ray? Why did you not do? When they go into the minute details in other professionals, what about their own profession? They have to see. Do they? It is not that they don't know the law. They know the law better than thousands of even, I will say, the legal luminaries, other legal luminaries. And they have the authority also. They are vested with the authority to interpret the law. And they are the highest authority, I will say. Now, the highest authority is knowingly not doing it. I will say now, I will say it is knowingly. It is not, it is only a few pages actor. Maybe the petition are not quoting, say. Maybe the election commission, the respondents are not assisting the court the way they should assist. But the court has its own ways. Na? The court can take up the act and read it and then interpret it. Let the court write down. I will like it because I don't have any hope. I still expect one thing, at least legal, purely legal, that the court should write. What do they say? Do they scrap section 19 of the Representation of People's Act? Do they say no? The elector cannot be registered by only these two conditions prescribed in the Act. We scrap this section. Two, do they scrap section 20, which says ordinarily resident? When 35 lakh, 3.5 million people have been removed by saying they are not available there. Does the election, the Honorable Supreme Court uh, think of that they will scrap that 20? Do they want to scrap 21, which says, section 21 of the Act, which says, which lays down, mandates that the revision of the electoral roll or the formation of the electoral roll, the de novo, shall be done as per procedure laid down. Number one, shall be done as per procedure laid down, and the electoral rolls shall be published in accordance with the rules framed under this act. No, do they want to scrap that? Let them scrap the section 21. Now 22 says, 23 says that they can seek only Aadhaar. And even if the Aadhaar is not given, they cannot remove. Let them scrap that also. Let the Supreme Court come out. We scrap this, we scrap this, we scrap this, we scrap this. Let them scrap Rule 8 of
No,
the
but if you look at the
registration
Bombay
of
High
electors.
Court, no, but if you have seen what Bombay High Court today said, he said the Bombay High Court has said that a person does not become a citizen of India merely by possessing documents like Aadhaar card, PAN card, or a voter ID card. This is what Bombay High Court said while refusing bail to a man who was allegedly from Bangladesh for entering India illegally. Now, this particular man is accused of staying in India for more than a decade with forged and fabricated documents. So it was in this context that just a bench of Justice Amit Borkar said that provisions of the Citizenship Act lay down who can be a citizen of India and how citizenship can be acquired, and documents such as the Aadhaar card, PAN card, and voter ID card are meant only for identification or availing services. So, what do you really have to say on the same
Yes.
day? Supreme Court says something, and then you have a another observation by the Bombay High Court on this.
No, no, no. The Bombay High Court is right in its own right. When I want that my citizenship should be decided, when there is a way laid down under Article 5 to 11. So I have to visit that of the Constitution of India. But if I am to be a voter, I have not to visit that 5 to 11. I have to visit only the Representative People's Act, various sections, the Registration of Electors rules, 1960, and the Conduct of Elections rules, 1961. I have not to visit 5 to 11. So here it is not a question. The question is, does the Election Commission have the right to decide whether one is a citizen of India or not? What right has it been vested with them? Let the Supreme Court say tomorrow onwards, today onwards, or already the Election Commission of India is vested with the right to decide the citizenship of a voter, and the Home Ministry does not, because two authorities cannot decide the same thing. So let the
No, but
Supreme Court
according
say.
to you, Dr. Garg, this day, the 2 days are scheduled for the hearing on SIR. Day one and tomorrow again, the hearing will resume. What are the big takeaways, according to you, from the day one hearing on SIR in Supreme Court? What have you gathered? What have you picked up according to the arguments
whatever
which went?
whatever I have picked up from your saying, if you feel, though you should ask these questions, with that Bombay High Court has said, that's a question I have to answer, and I should answer. The issue is that the Supreme Court is not taking all things into consideration, to my mind, because on one side they say we have removed 6.5 million people, 65 lakh people, 22 are dead, 35 are not traceable, and 7.5 are duplicate, and one are we don't know where they are. 35 have shifted permanently. Okay, fine. Are they not duty bound to provide the list of each category? Are they not duty bound to provide that who has told them that this person is dead? How did they come to know? I don't say they should produce a death certificate. They should tell the date of death. But they should have some source. If the election commission says 2.2 million people in a population 7.9 million, 7.9 million adults, 2.2 million are dead, then they should have some information. Huh? Either the parents or the relatives or the neighbors or some pradhan or some sarpanch or some NGO. Somebody should have given the information. Huh? Why should the election commission not tell, if the election commission removes the vote of a person saying that she is dead and is not ready to tell which source has informed him, then they can remove anybody. Is it a justice? Is it the law, implementation of the law? If I am declared dead, they have to tell now who has told them. I am not seeking that they should give the death certificate. I am not seeking they should give the death date of death. I am not seeking that they should give the cause of death. Though in death certificate, all these things are to be mentioned. We do mention, we doctors. But I am saying only declare your source. Where have you come to know that this person is dead from? Where have you come to know from? They are not ready to say. So it means it is a totally arbitrariness, and the Honorable Supreme Court is ready to agree to that arbitrariness. Then tomorrow I will say, oh, no, I have done it. I will do it like that. Because I have a knife, I will kill a person because I can open his tummy and I may cut anything because I am a surgeon. So I have to justify why do I cut this organ? If I am not ready to justify,
Don't
why
you
did I
think?
remove?
But
Huh?
are you hoping that Supreme Court will take a look at all the irregularities which have happened? Say, for example, the format of the voter list has been changed from readable to non-readable format. Then the exposes which happened on the ground, like the expose done by Ajit Anjum, expose done by Rahul Gandhi, expose done by Reporters Collective, expose done by Denik Bhaskar. There have been so many exposes. Will Supreme Court not take into consideration all these irregularities?
I ask you, with due regard, I don't want to talk to ladies to ladies like that. Do you think the Supreme Court is not alive to all these things? They are very much alive, but they are determined to decide something. Maybe they say it is a contempt of court. If they know everything is in public domain. Then, and the election commission time and again, do they not be fraudulent signatures? Now, if the Honorable Supreme Court is accepting the fraudulent signatures, the fake forms, the blank forms, the forms have not been distributed to the people, the BLO has not approached the people even once, and the election commission says claims that we have visited every house, we have collected the forms. Now, if the election, the Honorable Supreme Court is closing the eyes, is not ready to test this hypothesis. When say I am a petitioner, I am a citizen, I say they have not done it. The Supreme Court is not ready to test this thing. They say whatever the election commission says, this is right. Even if I produce a video, even if I produce the people, even if I produce the documents, they are not ready to accept. They say it is a trust deficit. Now, if I object to the procedure carried out, which is not as per law, which is totally illegal, which is a fraudulent procedure. If I bring it to the notice of the court that this is a fraudulent procedure, the election commission is doing,
No,
then
but say,
the
for
Honorable
example,
Supreme Court
sir,
tells me that is a trust deficit. What
no,
can
but
I
Dr.
do?
Kant, if you look at
Mm,
Yogendra
mm,
Yadav got two such people who were
mm,
declared dead, but they seem to
mm,
be alive. Then the manner in which Rakesh Dwivedi, who was the counsel of the election commission, he said that what is this drama, and why don't you, rather doing this drama, why don't you help these two people in uploading their enumeration form? So this was the kind of response which came from the election commission. What would you really say to this attitude? And of course, will the Supreme Court take into cognizance that yes, there have been irregularities, there have been people who are alive and they've been declared deceased? So, will Supreme Court just bypass it, saying that these are all systemic failures, they can be covered up, they can be rectified, and will not look at the larger problem which has happened en masse?
Nilu, first thing is when Joginder Yadav have presented those two people, they Mr. Trivedi has had no right to say it is a drama and all that. The honorable bench should have stopped him. But we told them, you produce the people, and they have produced. Now, Mr. The ECI on behalf of ECI, he could have at least said, okay, ji, let him prove the identity of the people. This is his right. But to say it is a drama and all that, why don't you help them? Who is he to say, why should I help them? I am saying their names have, why should I help? I am not paid for it. I am not duty bound. It is the duty of the EC. Why should he not tell, okay, why have their names been deleted as dead? Why should he not say, I will ask the election commission to send the people and get them registered? They're putting everything on me. They are charging heavy money. They are charging heavy salaries. They are getting all facilities. And they are forcing upon me. I am the Indian citizen. And they are not doing their duty. And the Honorable Supreme Court does not say, why did I'm nobody to tell, but I have been on some very small quasi judicial. We said, no, this cannot happen. Once the Mr. Trivedi said, whatever it is, once on behalf of ECI was said, why don't you go and the minimum response, if I say it is a question of fairness, the honorable bench should have said, no, we directly see to approach these two people and get them registered. And also explain to this bench how were their names put into the dead. Their names can be left out. Okay, I can understand. But how have they been put into the dead category? They have to explain. Why should they not explain? They put me in a category of a dead person. And then they say, tell you, oh, you go and help Terminal to get him registered. Where is the responsibility of the election commission? Where are there 1 lakh BLOs and 243, 2000, something like that, EROs and BLAs, 1.6 lakh BLAs and 4 lakh volunteers. Where are they? What are they doing? How much money has been spent? No, the Supreme Court is keeping mum on these issues. This is the minimum. Somebody is putting an allegation on me. Why the election commission has not done its duty, and it is a very big crime. A person is living, and you are telling is that is so. What as will be a bigger crime than this crime that you declare a living person as a dead person, and then you say no, 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 no. You don't agree that we are at fault. Rather, the person who tells that they are living, and then you say you go and do this thing. You do this thing. And the Supreme Court keeps mum on this. This is the minimum the Supreme Court had could have ordered. Okay, we direct the election commission that the registration of these two people be done. One, two. The election commission next time has to come to us by tomorrow. Has to come to us when the election commission wants to address us. Come up with the explanation of why were their names deleted, how they were deleted, and what are the measures that such things such ungenuine, such illegal things do not happen in future. If the
Right.
Supreme Court is not ready to say, I am not at this age. I have never seen in my life even very district judges, leave aside the district, even a sub judge, JMIC. I have not seen them doing that.
No, but
If
my
our
last
democracy, our
question,
judiciary has gone to that
Dr.
level, then it is really sorry.
No, but my last question to you, Dr. Garge, is that what can we expect tomorrow? Can we be hopeful of the SIR rolling back, or you don't see that possibility at all? Because India Alliance and Congress and other political parties have been demanding, the opposition parties have been demanding a rollback of SIR. So, is rollback something which looks very very far fetched?
You know, if it happens, it will be a miracle for me. I don't have any hope. It will be a miracle, and sometimes miracle do happen in this country. But
Right.
otherwise, I don't have any hope because only one line I will say. From one step, second step, third step, fourth step, I find that nothing has been done. If you just go on saying we'll do this, when last time they said you produce 15 people, we will scrap the whole exercise. 15 were not presented, two were presented. Now, then at least if the exercise were not to be scrapped, then at least some order could have been passed. Na? Insufficient evidence was there. Na? Or the bench should have observed Jogendar Yadav is wrong. These people are uh, fake. Those who have been shown as dead, these are not the identity has not been. The honorable bench should pass order on one or the other side. On the last point, I will say, had I been in place of Joginder Yadav, I would have not presented them, paraded them, frankly speaking. Because I have fought. Why should I parade them? I will put up a list. Okay, my lord, these are the people. If you want, I can present them. But these are the people who have been declared dead. This is the epic number and all that. Let the election commission come out with a counter affidavit. We have won these such cases here. We said, okay, the petition says this is the situation. The patient has died. Okay, let him come up.
Right.
Where is that dead body? Where has he been cremated or you can say
Right.
put
All right.
into the tomb? So the only thing with the minimum thing, only I will say minimum to minimum was we will say minimal. The minimal was to direct the election commission to register those people and to explain. The court has not done it. Rather,
Right.
court kept mum when the election commission advocate said, "Hey, why don't you go and get them registered?"
Hmm.
Should he make this? He's saying it is a drama. You do this. Court allows the election commission to do a drama, and under that drama, the court will do. It is not just like this type of thing, this type of language, this type of level. I don't have this any hope because I have been reared up in those days when the country was going into. Though we were very poor as a country, we did not have schools and anything, but we have been taught a high character.
Right.
We on whichever seat we sit, we do justice. We don't see who is the political leader, who is in power, what will happen to me, what will happen to my promotion, whether I will be chief or not. We don't bother. That is the way we have been taught.
All right, so we'll have to wait and watch what the second day of the hearing on SIR holds for all the people in Bihar, especially the SIR case. In totality, all the irregularities which have come to the fore, will Supreme Court tomorrow now take into consideration all of this? Thank you so much, Dr. Garg, for joining on the Federal. Thank you.